I know we talk a lot about how you apply the Second Amendment, but I want to talk about my Georgetown article in the Georgetown Journal of Law and Public Policy for just a few minutes. I want to show you the table of contents because I think this is an extremely important article for the Second Amendment community to pay attention to. I don't make any money off this, by the way. It's not like I get money off clips or anything like that involving the article, but it's all totally free. The reason why I want you to look at it is because it really does address exactly how the Second Amendment community should be arguing these various cases, these various issues that pop up by the anti-gunners, by people that are sort of ignorant, by judges that are trying to do the right thing but could get confused. So I want to really make sure that the Second Amendment community is on the same page as I articulated in my article in the Georgetown Journal of Law and Public Policy, Dangerous but Not Unusual. And I want to show you the table of contents to talk about it for just a couple minutes because I think it will be helpful to remind you of the process that we, as the smartest people in the room when it comes to our right to keep arms, follow as we interpret the Second Amendment and apply it to modern-day gun control controversies. Let's talk about this when we get back. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, author of many books on the Second Amendment, and of course this law review article we're going to talk about in 1 minute in the Georgetown Journal of Law and Public Policy, Dangerous but Not Unusual, Mistakes Commonly Made by Courts and Post-Bruen Litigations Associated with the Second Amendment. Check it out at the Georgetown School of Law, a link in the description of this video below. All right folks, so I just want to show you the table of contents here because I think to help you in your brain be able to sort of conceptualize and see how a Second Amendment analysis occurs. Obviously, we do a lot of this day to day on this channel, but I want you to step back and kind of see how I envision these kinds of arguments associated with the Second Amendment. And then I want to show the table of contents of this article because the table of contents really does track how your brain should be working when you're dealing with a Second Amendment controversy. And as I've discussed before, my longtime mentor, Ken Starr, the former Whitewater prosecutor and a former Court of Appeals judge on the United States Court of Appeals for the D.C. Circuit, always taught me, which is, you're an excellent lawyer when you can take things that are inextricably linked together and you can de-link them in your minds. And that's what I tried to do here to really break down how to analyze Second Amendment issues so that everyone can do it. So that's what I do in this article here. So let's just start from the beginning. Obviously, you know what I'm going to say. The first thing I talk about in this article is I talk about what's known as plain text analysis. Plain text analysis. This really interprets what the Supreme Court has called the Second Amendment's unqualified command. Every term in the text of the Second Amendment has been defined so far by the U.S. Supreme Court. Lower courts don't need to redefine these terms because it's already been done for them by the Supreme Court. The one exception to that, which I cover in footnote 3 in this article, is the definition of to be infringed, the definition of infringement, infringed, but I do discuss that and explain that the proper interpretation using the founding era dictionaries that the Supreme Court has already used in the other to define the other terms found in the Second Amendment's right to keep and bear arms. If you apply those dictionary definitions from the founding era, the same ones the Supreme Court has already shown that they support and they like and they embrace and they endorse, if you will. To infringe means to hinder. To hinder just means some sort of a basic restriction in any respect. That is enough to trigger basically that the text is implicated by the right of the people to keep and bear arms shall not be infringed, which is really just saying that it cannot be hindered in any respect. And if it is, this text is triggered and implicated, and you know what that means, the burden shifts to the government. And that gets rise to the second section of this article, which we've talked about before, and this is very important. I don't know how many of you know this, but in the section here, I talk about how the burden shifts to the government, which of course you do know, but I point out that literally is somewhere in the order of magnitude of a dozen times in the Bruen case alone. The Supreme Court made clear that once that burden shifts, or I should say once the text is implicated, the burden shifts to the government. And they literally have like 6 to 12 different ways they explain the burden is on the government. Now, this is very important because to the extent there's any doubt whatsoever about whether or not there's a long-standing historical tradition of firearms regulation, if there's a historical ambiguity, if there's silence in terms of there is no regulation, it means that freedom wins, liberty wins, the right to keep and bear arms wins, and government loses, government gun control loses. Very important to understand section 2 of my article dealing with what the burden means on the government when you move to the historical section of the text first, then historical tradition of regulation, analysis, part of the methodology. Then, of course, this article moves to section 3, which I call the fork in the road. Specifically, this is the fork in the constitutional road, which really just asks one question. Has the United States Supreme Court already set forth the appropriate constitutional test to resolve the case that's in front of you? For example, we know that the U.S. Supreme Court has already set forth the constitutional test and has already done the historical analysis of what historical tradition of firearms regulation has existed in American life at the time of the founding in the 2008 Supreme Court decision of District of Columbia versus Heller, where they said there is a historical tradition of banning the carrying of dangerous and unusual weapons, conjunctive, and as extension from there, based that, and also on the Miller decision from 2034 or so, I should say 1934, I apologize for that. Based on all that, the one constitutional test that's unequivocal by the U.S. Supreme Court is that if an arm is in common use by Americans for lawful purpose, it cannot be banned. Many lower courts have screwed this up 6 ways to Sunday, including major appellate courts like the Seventh Circuit Court of Appeals out of Chicago. Terrible anti-gun panel on that one with Judge Easterbrook and Judge Wood, who is no longer on the court, of course. The Fourth Circuit, led by Judge Harvey Wilkinson, another total screw-up, and the Ninth Circuit is full of these kinds of decisions. But again, the fork in the road is once the burden shifts to the government, you have to ask, has the Supreme Court already decided the constitutional test to apply to the controversy that's in front of you? If the answer is yes, you have to apply the constitutional test, period, full stop. And of course, if the answer is no, if the Supreme Court has not already resolved the constitutional test, this is where courts have to begin the process of analyzing historical analog laws to the extent there are any. And this is the second path. Again, there's two paths in the road. You got to pick one. If the Supreme Court's already decided, you go down one path and apply the law of the Supreme Court. If it hasn't decided, that this is where the lower courts, I should say, have to start to engage in historical analog work and trying to figure out, are there laws? And if there are laws, are there a sufficient number of laws that are well representative at the time of the period and the relevant time periods and so on to justify this modern-day gun control law? And that is where I get into the next section of this article, is what happens if you're dealing with a case where the Supreme Court has not yet decided the constitutional test to be applied. And this is really a detailed analysis of the different ways to assess, is a historical law a historical analog? And this is very important because this is where there's a lot of confusion about, by writers and so-called journalists. Here's the bottom line. And I talk about this in the article, when you are talking about, is there a historical tradition of firearms regulation that is analogous to the modern-day gun control law, you have to look at a particular type of history. You are not just looking at airy-fairy historical narratives and I stand on the river, I stand on the riverbank as the river and the water of history passes me by. Is Abraham Lincoln gay? What period undergarments were worn by Queen Elizabeth? Queen Victoria in the Victorian era? Did Queen Elizabeth have a lover, and was Drake the lover, back during that time period? And why did the Spanish Armada, not succeed in invading England, and so on and so on and so on? None of this is really particularly relevant to establishing whether or not you have a historical tradition of firearms regulation. Because the first point here is that the analogs, the historical that you're looking at, the history you're looking at, have to be historical analog laws. They have to be laws, not any kind of airy-fairy history. They have to be actual laws on the books that were actually enforced against people in a particular way that pertain to firearms regulations. That's the first thing. So who is in the best position to analyze, are there historical laws, and what do those historical laws mean, and how were those historical laws applied? Answer is, we know. That would be called lawyers and judges. And this is why Chief Justice John Roberts has literally said that analogical reasoning, assessing laws, is what lawyers do. It's the bread and butter of what lawyers do. So when people say that I'm not a historian, how can I decide Second Amendment cases? You just say that's BS. BS. Why? Because lawyers and judges have one job, which is to look at historical laws and to apply them to controversies today. In fact, all lawyers really do, if you think about it in many respects, is look to the past. We look to past laws that have been acted in the past that are still binding today and apply them to today's controversies. If you're trying to resolve a lawsuit, you go back in time and say, what happened a week ago? What happened a year ago? What happened 5 years ago? Right? You look at the history, not just of the laws that apply, but you look at the history of the facts. So much of what you do as a lawyer is backwards looking anyway. So to somehow say that lawyers are not historians is a cop-out. It doesn't work, especially when you're trying to analyze a Second Amendment case, which again, the only kind of history that matters is historical laws. The other kind of history doesn't count. Then I go on in that section and talk about that not all history is created equal, because you need to look at the relevant time period. The Supreme Court has repeatedly says, even though I know they left open a question about a scholarly debate between the 19th century versus 1791 in terms of how to interpret the Second Amendment, the reality is this, that the Supreme Court has repeatedly says that you have to interpret the Second Amendment as it applies against the federal government the same way as it would apply against the state and local governments. And, it's already established that you look to 1791 really to understand the meaning of the Second Amendment in the modern day America. You can only have one interpretation applicable to everyone. And whether you look at the Espinoza case involving the First Amendment, the reality is the Supreme Court always goes back to the founding era, going all the way back to cases like Marsh versus Chambers dealing with the First Amendment. They're always looking at the founding era as the best, most important law and history to figure out what did the founders mean when they adopted the Bill of Rights, notwithstanding the fact that the Bill of Rights does not apply against the states and localities until after the Civil War with the adoption of the 14th Amendment and, of course, the adoption of the incorporation doctrine. So I discuss all of that, why at the end of the day, notwithstanding when the Supreme Court says there's a historical sort of a scholarly debate going on about the time periods of which is relevant, it's pretty clear that the right answer ultimately will be 1791, and I discuss that and cite to my other article in the Harvard Journal of Law and Public Policy, which I do reference in this Georgetown article here. Then I point out that racist and otherwise unconstitutional laws back in time, in other words, if you're dealing with a racist law from the 18th century or a law in the 18th century that would be viewed as unconstitutional today, that is a no-go zone. Even the Joe Biden Department of Justice has abandoned citing those laws, and I think enough judges, including, for example, Judge Roger Benitez in California, said, yeah, you can't go there. So I talk in detail all the different courts that have rejected those kinds of laws as a basis for giving rise to a historical tradition of firearms regulation that could justify modern-day gun control law. Then I talk about how the analogs have to be, how these laws have to be analogous. You look at the why they were enacted and the hows. I give a bunch of examples of laws that violate the whys and violate the hows so that people don't make those same mistakes and how they have to all line up, and I discuss that in great detail. And of course, I also talk about how dicta of the Supreme Court is generally not binding. I know a lot of lower courts say, well, if it's Supreme Court dicta, we kind of follow it. It's kind of what we do in the circuit, and I understand that. It's not insane, but there's no, and this is the key point to understand about Supreme Court dicta in the context of the Second Amendment. This is the critical point. Write this down if you're, a student, if you're a lawyer, or if you're a scholar, whatever it is, and that's this. Yes, it's true as a general matter, dicta by the U.S. Supreme Court is binding and considered pretty persuasive by lower courts, but you have to interpret not just dicta in these Second Amendment cases. You have to interpret the dicta in the context of the fact that they're literally telling you, the Supreme Court is literally telling lower courts, you must engage in this text-first historical tradition of firearms regulation analysis. So you have to do the work. You cannot get out of jail free just by citing the dicta. You cannot skip over the hard work of doing the analysis of text first and historical tradition analysis of analog laws by just citing to some dicta. That is a cop-out. It's not allowed. I discuss this in great detail in this article here. And the final two sections, which I won't belabor the point, as I identify all the different types of gun-related laws that are going on, that are being litigated, everything from arms ban cases to young adults dealing with, gun bans for 18, 19, and 20-year-olds, to sensitive places, which is a euphemism for government-mandated gun-free zones, licensing regulations, how those are to apply here, and of course, tax cases where they're trying to tax ammunition purchases, they're trying to tax gun purchases, why these are unconstitutional. And again, throughout all of this article, and by the way, then what I do is I analyze each of those categories of legal challenges by applying, I think, the proper law, so that if courts look to my article, or if people look to my article, they know exactly how to decide, how to apply the Second Amendment case law to these particular controversies. And that's why I wrote this article, because again, the title of the article is Dangerous but Not Unusual: Mistakes Commonly Made by Courts in Post-Bruen Litigation. I was trying to identify all the common mistakes made by the lower courts in screwing up these Second Amendment cases, because of course, since I read so much of this for the purposes of, for example, this channel and my general scholarship anyway, as an academic, I guess, I wanted to flag these things so people don't keep making the same mistake over and over and over again and become Charlie Brown, with Lucy pulling the football out from under Charlie Brown every time he tries to kick it. And I think that a lot of lower courts are trying to get the Second Amendment right, but they make mistakes because they don't see a lot of Second Amendment cases, and a lot of judges, even if they're familiar with the Second Amendment, may not be familiar with firearms technology. So you have a double whammy there and a double problem for the Second Amendment community, which again is there's not a lot of Second Amendment litigations out there in front of particular judges, so they never become familiar with the body of law, which would be in contrast to, let's say, the body of contract law or tort law, where they're probably very familiar with that because they see cases like that every day. And to make matters even worse, a lot of them have never even touched a gun, know nothing about guns, and you can literally tell some of these judges that know nothing about guns that there is no different in firing power or in stopping power between a .308 and a .556, and their eyes would glaze over and they wouldn't even have any idea what I just said. And that, of course, is a problem which I'm trying to address, with this channel and through my scholarship, to try to make sure that Americans at all levels really understand the right to keep and bear arms, the history here, the Second Amendment, how to understand it as lawyers and judges and scholars understand it and apply it. And that's what I'm trying to do with this article in the Georgetown Journal of Law and Public Policy, which is totally free. You can download it from the link in this video. So there you have it, folks. Hope you learned something here today. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe to this channel. We're trying to get to 200,000 subscribers, and I'll talk to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.